I have been transferred, my lord. This is a non-transferable post, my lord.
As per the non-transferable post.
Yes, my lord. Rule 15 of the Bihar Panchayat Elementary Rules 2015, my lord. Sub Rule 15 stipulates that there is a non-transferable post. Only in exceptional circumstances, my lord, I can be transferred, my lord, and without citing any reason. Primary thrust, my lord.
Come to the order.
My lord, if possible, my lord, this case is possible, my lord.
Where?
Are we possible, Mr. Maglam is on.
Argue.
As far as this case is concerned, my lord, election 9 series 9 has been put under challenge, my lord. In this case, my lord, basically on two facets, this election 9 has been challenged. First, my lord, this order has been passed without adhering to the principles of natural justice. No show was at all was shoved to me, my lord. And second, my lord, the first of all, second part is that, my lord, I have been transferred, my lord. This is a non-transferable post, my lord.
As per the non-transferable post.
Yes, my lord. Rule 15 of the Bihar Panchayat Elementary Rules 2015, my lord. Sub Rule 15 stipulates that there is a non-transferable post. Only in exceptional circumstances, my lord, I can be transferred, my lord, and without citing any reason. Primary thrust, my lord.
Come to the order.
My lord, section 9 is, my lord, page 27, my lord. प्रखंड शिक्षा पदाधिकारी और के पत्रांक 291 डेटेड स्वयं सो द्वारा प्राप्त पत्र एवं संलग्न प्रतिवेदन के अवलोकन के पश्चात तथा अनुमंडलीय लोक शिकायत निवारण पदाधिकारी मुजफ्फरपुर पूर्वी द्वारा परिवादी की अनुन्य संख्या स्वयं सो में पारित आदेश जिला शिक्षा पदाधिकारी के सो के आदेश पत्रांक के निर्देशा आलोक में प्रखंड शिक्षा समिति दैट इज ब्लॉक एजुकेशन कमेटी की बैठक में लिए गए निर्णय के अनुसार श्रीमती अनुपम कुमारी प्रभारी प्रधानाध्यापिका डगरामा अजय के औरई के विरुद्ध लापरवाही और अनियमितता के प्रमाणित आरोप के कारण इन्हें प्रभारी प्रधानाध्यापक के पद से हटाया जाता है। श्रीमती अनुपम कुमारी के विद्यालय में बने रहने से विद्यालय के प्रशासनिक एवं शैक्षणिक माहौल पर प्रतिकूल प्रभाव पड़ने की संभावना है, अतः उन्हें स्थानांतरित करते हुए उनके अगले आदेश तक उच्च मध्य विद्यालय बैरिया औरई में प्रस्थापित किया जाता है। साथ ही उसे विद्यालय में इन्हें प्रभारी प्रधानाध्यापक की भूमिका से वंचित किया जाता है। दिस अपॉइंटिंग कमेटी दैट इज अ ब्लॉक एजुकेशन कमेटी, माय लॉर्ड, ब्लॉक एजुकेशन कमेटी, दे हैव टेकन दिस डिसीजन स्ट्रेट अवे ousting me, my lord, from the post of in charge headmaster. First, my lord, the background of this case is that, my lord, initially way back in 2013, my lord, I was appointed as a block teacher, my lord. In 2016, my lord, on the retirement of the headmaster, my lord, I was made in charge headmaster, my lord. My lord, a complaint was filed for the Public Grievance Judicial Commission by one complaint, my lord, on two grounds, my lord, citing that the funds of the midday meal scheme is being transferred lately, and second, my lord, even though they are the students who are actually present in the classes, my lord, those numbers are exaggerated, my lord. That grievance was considered by the SDO, my lord, who was the Public Grievance Judicial Commission. No order was passed, my lord. Against that, my lord, the complaint approach would the DM, who is the second appellate authority, my lord. So DM also issued that a departmental proceeding be initiated against that person if at all any action is required against the petitioner. Now, after the order of the DM, my lord, the block appointment committee, my lord, which is the appointing authority, my lord, without issuing any show cause to me, my lord, they straight away said that on the basis strength of the previous orders, my lord, the letters, my lord, the charges are put against me, my lord, and I should be removed from the post of in charge headmaster, and I should be transferred from the said school where I was posted as in charge headmaster, my lord. Now, basically I'm telling, my lord, at least I should, one show cause should have been served to me, my lord, that at least I was able to reply, my lord. In the letter which has been, even the authorities has basically conducted inquiry on the complaint of the complainant, my lord. They came to the finding that as far as the second allegation is concerned, the exaggerated amount of the presence of the student, my lord, that is not found, my lord. And as far as the one allegation regarding the transfer of funds, lately only that has been found, my lord. That transfers are found, the funds are being transferred bit lately, my lord. Only that allegation was found to be true, my lord. But in spite of that, my lord, when the appointing authority, that is the block education committee, they choose to take session of this matter, my lord, they straight away came to the finding that we found all the allegations against this petition to be true, and hence we are ousting him from the post of in charge headmaster, and we are transferring her from the post, my lord. Now, I should fairly submit, my lord, this after the passing of this order, my lord, which has been on 1st of November 2022, my lord, I have not been relieved, my lord. I have taken a casual leave, my lord. So basically, I'm taking chances with this honorable court. On this limited, on they should serve me a show cause, my lord, I will reply. Otherwise, they should just pass order, any reason order, any
So
particular.
come to rule 15.
Page
3.
15.
You have the rules with you?
No, actually, unfortunately, I don't have that. At the last point, I was being asked to take adjournment, my lord, so I went to the brief. My
मेरा
lord.
भाई डीटर साहब उनको रूल 15 का 3 दिखाइए कि फ्लैग लगा हुआ इसके ऊपर
My lord.
3.
In the case of proved financial irregularities, moral turpitude or other serious charges, the member secretary of the recruitment unit shall transfer headmaster teacher for one time on administrative ground in the interest of school and students. The approval of this action shall be given to the chairman of the committee constituted for the purpose intended. My lord, as far as only I'll be, as far as your worship is concerned, financial irregularity would be the case which I'll be implicated, my lord. But at least, my lord, I should be given the show cause, my lord. And that allegation, unless I did my show cause, would be considered, my lord. My lord, no, that principles of Audi alterum pattern requires at least I should be heard, my lord. Unless until it would be futile exercise, my lord. Because I am bound to explain why funds were transferred late, my lord. And that has not been considered up to
So
now.
that you were not given any opportunity of hearing.
My lord, the entire annexure, my lord. My lord, but no order which whatever annexures that I have annexed, my lord, nowhere it states that my grievance, the defense has been considered. Whatever annexure 1 to 7, all the letters by the authority, my lord, nowhere states that this defense have been considered. And moreover, my lord, at no point of time any hearing has taken place, my lord. There should be a hearing, my lord. I should file my representation, my lord. That representation should be considered and order should be passed. As simple as that. Very short facet of law, my lord. That I should be heard. I well agree that if I am found guilty, I should be removed from the post. I should be ousted from the post. But at least they should give me show cause. I am bound to explain why, if there is a delay in transfer of fund, my lord, I should be. I am bound to explain it to you. If it is not found favorable to the authorities, they are bound to pass any restrictions against me, my lord. That is the limited grievance of mine, my lord. My lord, annexure P8, which is the order of the second authority, my lord. It is upon this order of the second authority, which is the district magistrate concerned, my lord.
It's not so, Mr. Counsel. You were given a show cause.
My lord,
You have yourself mentioned that
my
you were
lord,
asked to
at
give
the
a
first time, my lord, that show was considered, no order was passed by the SDO, my lord. Kindly appreciate this fact, my lord. When the complaint was filed before the SDO, my lord, SDO directed the block education officer, my lord, block education called me and asked me the show cause, my lord. That show cause was constituted by the level of SDO, my lord, and no adverse order was passed by the SDO against me, my lord. And that is the only show cause consideration by the SDO, my lord. And after that, at the level of the appellate authority, which is the district magistrate, my lord, what they have directed, they have not passed any stricture against me, my lord. What they have asked is that a proceeding should be initiated against me, my lord. And as per the strength of the election P8 also, my lord, a departmental proceeding was required to be initiated against me, my lord. I was supposed to be heard, my lord. And once I would have been heard, I would have put my defense, my lord. That defense would have been considered. Rightly or wrongly, I could have any strictures or any order punishment order can be passed against me, my lord. That is the only limited grounds, my lord, I am willing for this honorable court, my lord.
all right.
Technical, my lord.
Okay. The petitioner assails the order dated 1/11/22, whereby she has been removed from the post of in charge headmistress of middle school Dakrama or district Orai, and has been further transferred to upgraded middle school area. Mentioning there is that certain allegations have been found to be proved by the grievance redressal by the subdivision of SDO cum Public Grievances Redressal Authority. Who has not given a fair opportunity to the petitioner to submit his defense, submit her defense. Learned Counsel submits that a complaint was registered against her by one Jagannath Sahni and before the SDO cum Public Grievances Redressal Authority. The said authority did not issue notice to the petitioner. However, explanation was sought by the district program officer,
Block education officer.
by the block education officer from the petitioner, whereafter the Public Grievance Redressal Authority did not take any action further against it. The concerned complainant filed a second appeal before the district magistrate. And the district magistrate directed the block development officer to conclude the departmental proceedings within a time frame. But no departmental proceedings were initiated against the petitioner, and without framing any charge, the petitioner has been transferred. Learned Counsel submits that as per Rule 15(3) of the rules of 2020, the petitioner can only be transferred if the charges are proved if a charge of financial irregularity is proved against a teacher. I have considered submission and carefully considered Rule 15 of the rules of 2020. Rule 15 within bracket 3 of the rules of 2020 reads as under, quote, from perusal of above, it is apparent that while the main rule 15 does not allow transfers of teachers generally, however, certain exceptions have been carved out. In terms of sub-rule 3, as quoted above, it is apparent that if there is any charge of financial irregularity, the person may be transferred. Question whether the charge is to be finally proved would, in the opinion of this court, not an embargo to transfer the person if in a inquiry the charge is found to be prima facie proved. In the present case, there is a report of financial irregularity against the petitioner and she has therefore been transferred. No interference is therefore warranted. The petition is dismissed.